Hello, my name is Richard Wenner, and in this video I'll be discussing when you should make or update your will. We all realize conceptually that it's a good idea to have a will and to update it regularly. However, if you're like most of us, making your will usually drops to the bottom of our priority list. Why? Because no one wants to think about dying until the threat of imminent death stares us in the face. For this reason, most people wait until they're either going on vacation or entering the hospital before they'll finally give their instructions on the creation of a will. However, waiting to the last minute might be too late. If you want a will that will actually implement your wishes, it can take some time before your lawyer will be in a position to properly draft the document. Here's the kind of information your lawyer needs to do an effective job. A summary of your personal situation, depending upon the circumstances. This will include the full legal names, addresses, and occupations of your spouse, your children, and possibly your parents or your siblings. Any other parties whom you wish to designate as beneficiaries of your estate. If you've been previously married or lived in a common law marriage, your lawyer may need to know the names and addresses of the former spouses. If you have children from a prior relationship, he or she will need the full names of these children, their ages, and where they're living. Who has custody of those children, if they're underage. Your lawyer is also going to need an accurate summary of your finances. The object of a will is to distribute your worldly belongings and your wealth to those beneficiaries whom you want to receive it. Your lawyer will need a careful summary of your assets, as not all of them will be governed by your will. These include RRSPs, RIFs, tax-free savings accounts, life insurance, pension benefits, and others. These types of investments require the investor to designate a beneficiary on death. That designated beneficiary takes priority over the will. Before seeing your lawyer, you must give careful thought to whom you wish to appoint as your executor, whom you will act as your alternate executor in the event that the primary executor is unable or unwilling to act. If you have underage children, who will be the guardian of those children? And who will be the beneficiaries? If you have underage children, do you wish these children to receive their inheritance at age 19, which is the age of majority in British Columbia? If you prefer for your children to inherit at a later age, such as 25 or 30, you must give thought to the appointment of an executor who will be alive when that child or children reach that age. What if your children do not survive you? Do you want to make provision for alternate beneficiaries? As you can appreciate, making a will requires a great deal of thought. It's not something that should be taken lightly, and it's not something that should be done at the last minute. As an experienced wills and estates lawyer, I can simplify the process, work with you every step of the way, and make the task a whole lot easier. Give me a call. I look forward to working with you.